Don't repeat anything you've already said, Mr. Raphael, but some of us are still struggling to hear you on occasion.
I do apologise.
Just to make sure we do get the transcript, I wonder whether you might point both microphones towards you.
Well, without repeating myself, one point I hadn't touched on ground one was how do you play it out in terms of downstream pass-on. And this comes back to the centering point of the 50%. And our short position is he's not in that position simply starting for 50%. You cannot infer that he's gone in our favour from a midpoint. That's the wrong way to look at this one. Instead, what's happened is he's taken into account the factors against pass-on so far as he's given them weight so far, but in so doing has restrained himself by ASDA, and that has led him down to 65% from 100. And he would have gone further but for ASDA. Well, that is ground one. Then that takes me on to ground 2A. It was mentioned briefly that we had said lagged dependent variable in ground 3 rather than lag of the dependent variable. I don't believe anyone says anything turns on that. It was always clear from our grounds of appeal and from our skeleton that we were saying that the lag price models should be adopted in the way modelled, which includes them in the explanatory variable section. That's totally clear also from the skeleton. For what it's worth, I am told by Mr. Coopin it's actually very common to refer to lags of the dependent variable wherever you put them as lagged dependent variables. And you actually see that in Professor Bernheim's report. So, but I don't believe Mr. Moose took a point on that. The point Mr. Moose did take was an argument that the grounds did not challenge the judge's subsidiary reasons for decision. I'll ask you to turn up the grounds in tab 1. And, my lords, this is a bad point. We say, at paragraph 3, the judge made an obvious error in finding that regression models, including a lag-dependent variable, should not be used in estimating the overcharge. That comprises all his reasoning. In our skeleton, we then, of course, engage at some length with all of his subsidiary reasons, paragraph 111 to the extent it's necessary, paragraph 114, paragraph 115. Permission to appeal was given on the basis of that skeleton. My learned friend's respondent skeleton engage with those points. There is no doubt that the challenge to the judge's subsidiary reasons are part of the appeal. This is a point of the merest formality. The real significance of that move by Mr. Noosa is this. He did not engage with our arguments. I would ask you to consider how much he did not contradict of what I said in opening. And the consequence, therefore, is that all the points I made to you on why the judge's subsidiary reasons are invalid, it never having been suggested before that moment, those were not issues in the scope of the appeal, were not counted. So, for example, the 18-24-month point was not counted, and many others. The point that 115, the judgment is incoherent because it confuses short-run, long-run coefficients, was not counted. Likewise, a linked decision was made not to pursue the respondent's notice points on the basis of this same false point that we weren't challenging the judge's subsidiary reasons. But obviously, we were. That's always been what this appeal has centrally included. So where you are left with this failure to challenge most of the points we are making, is that Mr. Moose's case in the end came down on ground 2A to one point, which is the evidence of price persistence. And he actually even put that very narrowly. He said the only point was whether or not the judge had accepted it or not. But in fact, of course, there are two sides to that point. Because firstly,
just before you come on to the evidence, when you say price persistence, can you be specific about what price persistence you're talking about?
I'm talking about persistence of price within the data, meaning that price in a subsequent period includes as one of its cause to effect price in a previous period.
In a non-cartelized world?
In the non-cartelized world, yes. Well, to be precise, there is price persistence in the actual world as well, but what you are seeking to identify is whether there is price persistence in the counterfactual world. That is what I need to prove. So, but to make my point about the narrowing of the way Mr. Musa put his case, he said, well, the only issue is whether the judge accepted there was evidence of price persistence. But that is too narrow, because assume that I can show you that there was clear evidence of price persistence, which the judge should have taken into account. Then even if his findings at 134 to 137 don't adopt it sufficiently, I'll show you they do, he has still failed to take that evidence of price persistence into account when modelling, because he has certainly not rejected the evidence of price persistence in any way. Now, what was the evidence here? You need to distinguish what evidence is and what it is used for. Because the confusion running through Mr. Musa's submissions was to say that because in 134 to 137 the judge used the evidence for the purposes of identifying the post-cartel overhang, therefore that is all the evidence was about. But that is incorrect. In fact, what you have is evidence of price persistence, which is market evidence, and then the judge uses that evidence for the purposes of talking about post-cartel overhangs. But there are two findings, and you must not confuse the first with the second. Now, to understand this, it's worth having a clearer picture of what the actual evidence was. Now, if I could ask you to turn up the supplemental bundle in Physical Bundle 2, tab 8, page 413. Mr. Parker had done a regression analysis using price data for the dependent variable. That data came from LG. This is summarized at paragraph 1.14. Mr. Parker's regression analysis relies on the data from a database provided by LG. So that is the data. And it is the data that for every single permutation of the model both experts are working with throughout. Dr. van der Laan's analysis of that data to identify price persistence is at 4.3.4. He has done, it is true at this stage for the purpose of estimating as a second stage post-cartel overhang, that he has done an analysis of the data. And he says, figure 2 below shows average LCD panel prices used by Mr. Parker in his analysis. This is not disputed, but just, I appreciate there may have been some confusion about this.
I'm sorry, Mr. Raphael, I'm suffering a technical problem on my screen at the moment, and I've just not been able to get my machine to respond at the moment. So you're going to have to give me, I'm going to have to look at the manual.
Shall we? Yeah,
can you just give me the reference again?
Yes, sorry. Indeed. So we're at page 438, Physical Bundle 2, tab 8. So he says, figure 2 below shows the panel prices used by Mr. Parker in his analysis. So when you turn over the page and see the figure, which is the one the judge replicates in his judgment, the point is, I apologise if I didn't make this clear enough before, this is the data that everyone is using. It is the whole price data for the dependent variable used for all the models. And he has then tested that data, you see 4.3.5, and he says, my tests indicate that the LCD panel prices that Mr. Parker uses to estimate his regression models are persistent. And he then gives his results in table 8. There's a forest of underlying mathematics, but because those weren't disputed, we just used table 8. But if you go then to the bottom axis of figure 42, the point is the data that has been analysed to prove price persistence is January 2001 to October 2008, the whole of the LGD database. And so what Dr. van der Laan has found in table 8 and summarised in 4.37 is price persistence in all of the data set, before, during and after the cartel. That was the statistical analysis. Now he then used that, because it was logically relevant at that stage, for the purposes of saying, oh well, if I'm asking myself, has the cartel price overhung past the end of the cartel, price persistence is part of why you would say there is an overhang. That is stage 2. The statistical finding, interestingly enough, conducted wholly innocently, without any eye on what overcharge might result if you plugged it into a model, that's significant in itself, is a simple finding as to what the data looks like. And that tells you not just about the actual, but about the counterfactual, because it is modelling the whole data set, including before and after the cartel, point 1, and point 2, because there is no reason to think that price persistence, even during the cartel period, would be any less as a phenomenon of the market. So that is the data. The other point to pick up is this. Mr. Musa made much of some oddities in the data and how you had some odder findings, for example, in the later periods. There's a 1 star in 6 months, for example. But the point is that the strength of the relationship shown by this data is in 2 to 3 months, because that's where you get the consistent 3 stars and the consistently correctly signed indicators. And that is why Mr. Parker accepts it. Now, we need to turn then again to the memorandum, which is in Supplemental Bundle 2, tab 17. Supplemental Bundle 2, I think Physical Bundle 3, tab 17. And it's item 20. Now, recall again that at this point nobody had tested what price persistence would spit out of the model if it was plugged in. Nobody had done that test yet. Mr. Parker tested 1 month, but not 2 to 3. Page 1114. And then Dr. van der Laan says, Dr. van der Laan presents evidence that there was price persistence, i.e. that the price in an LCD panel in a month is partly determined by the price of the LCD panel in the previous month. That is the statistical conclusion. He then later in that paragraph goes on to talk about the post-cartel period, but the statistical conclusion is in the beginning. And Mr. Parker argues with some of the other points about post-cartel overhang in his first paragraph, but in his second paragraph says, I do not consider that Dr. van der Laan has demonstrated price persistence for 9 months in his analysis in van der Laan 2. His analysis shows effects, not just correlation, effects in months 1 and 2, but no significant effects for the later months, for monitors. For notebook panels, moving on to the next page, Dr. Van Loan finds significant effects, real effects, not just correlations, in months 1, 2, and 3, but after that, less good. It's not plausible that you'd have no impact at 4 months, but impact at 9 months, as I would expect the impact to reduce over time. I therefore consider that Dr. Van Loan's analysis is consistent with price persistence for at most 2 to 3 months. He is accepting a real effect, having gone away and crunched the data himself, obviously. Enough. And this was an extremely striking moment. Data was accepted. Then Dr. Van Loan went away and plugged it into the model and just saw what happened. And you see that in Van der Laan 3, which is in volume 9 of the supplemental bundle, I think physical, tab 9, physical volume 2, and he discusses this at paragraph 1.3.1. In Van der Laan 2, I reported tests for persistence in monitor notebook panel prices. This is page 506. I reported tests for multiple panels. Results show statistically significant impacts for 1, 2, 7, and 9 months. The notebooks 1, 2, 3, and 6 months. In the joint statement, Sparker writes he considers that my analysis is consistent with price persistence for most 2 to 3 months. And he then, using that clear evidence, which everybody knows, logically applies directly to the regression model because it is modelling an effect in all the price data, the exact same data that is fundamental to every single model. So there's just no question about whether it crosses applies. No one could have dreamt of that until clever counsel came up with some arguments to that effect. And then he says, I plugged it in, and he gives you the results in 1.3.3, 1.3.4 following. Now, so in terms of the question, put I think a couple of times by my Lord Justice Snowden, where do I see price persistence in the graph? The answer is it's simply part of the data. The price persistence is part of the explanation of why that graph looks how it is. Were there no price persistence, it would be different. But you test for that in the statistical analysis in Table 8, which shows you the relationship between prices. And that is an accepted result.
This is, you're saying that if the real data shows price persistence, yes. That is both before the critical times would be before the cartel operated, presumably, because once the cartel has started operating, you've also potentially got price persistence because of the cartel itself.
Well, not in the same way, because you've seen the data set goes to the end of 2008. And remember, the judge found only limited post-cartel effects.
Maybe a little bit off at the end then.
Well, a year plus. So that's the first point. But there is the second point, that there is no logical reason to assume less price persistence in the counterfactual even during the cartel period. Why, logically, would the counterfactual non-cartelized economy be in any way less subject to price persistence? There's no reason to assume it. In fact, the contrary is the case. Because let's assume you have the market moving upwards with some price smoothing for everybody in a normal way. Normally you have price persistence, that's the standard. But the cartelists are able to shift it upwards faster if they wish, because they have market power. And likewise, if the market is otherwise moving downwards, the cartelists are able to slow that downwards increment because they have market power. They are less subject to the demands of customers. So the inference that you cannot infer from the actual to the counterfactual is wrong. And there is no logical reason given for rejecting that inference.
Hang on. if cartelists could slow the downwards movement of prices in response to market
Yep.
factors, then there's higher price persistence in that circumstance as a consequence.
Yes, but they're also able to slow it going up. Sorry, increase it going up more fastly. But you don't. What you do not have is a systematic reason to assume that price persistence will be different overall in the counterfactual. There's a symmetric effect potentially. But, so that then is now, to be clear.
So where is the clear statement that absent the cartel, prices are persistent?
In Dr. van der Laan's evidence,
Well, anyway.
he says it at 1.3.2. He just takes the data and says where there's evidence of or indications for price persistence, not addressing it in a regression model can bias the coefficient towards 0. So you should include it.
So in our case, in our case, the evidence you showed us, as I understood it, the graph and paragraphs below it for Mr. van der Laan's evidence, was addressing 4.3.5 at page 439, for example.
Yeah.
He says, my tests indicate the LCD panel prices that Mr. Parker uses to estimate regression models are persistent.
Yes.
So those actual.
Yes, necessarily he can only do a statistical model of actual price persistence.
Right, so that is persistence by reference to a cartelized world, at least in part.
Yes, but it's nearly 3 years after October 2008 for the post-cartel period, and it's up to a bit less than a year before for the pre-cartel period. And for what it's worth, my lords, the judge did not think that you would have less price persistence in the counterfactual. Sorry, yes, he thought, in fact, that the cartel would change its kind. If you get 114 of his judgment, he concludes that the cartel, if anything, will reduce the price persistence impact. Now, but to stress, my lord, these concerns that are troubling you were not concerns expressed by anyone. Mr. Parker's answer was not, you can't draw the inference. Mr. Parker's answer was, this is just a correlation, it's not a real effect. That was his answer. But that was a change of heart after he had seen the impact.
I'm sorry, 114. Just
Yes.
Run past me again what you say I get from 114.
Well, I don't want to take too much from what the judge said on this, because he misapplied this to the counterfactual. But what the judge says
Whether a cost-price lag, and that's...
has occurred is fact-sensitive. If and to the extent the question is one of...
Hang on, what about the middle sentence you just missed?
There is no... Yes, but that's because he's ignored the data. That is precisely the problem. That's the heart of our appeal. That second sentence of 114 relies on him ignoring the tables we have seen.
Sorry, I thought you took us to this paragraph. I was trying to keep pace. I thought you took us to this paragraph to show that the judge accepted that...
When he then goes on and says, if and to the extent the question of argument, I consider the assumptions made by Dr. van Laan are likely counterbalanced, that's where he's talking about economic arguments for price persistence, by the fact that the reason for the cartel was to control prices by price fixing and an increase in supply. Such motivation suggests it would be unlikely to any significant delay in changing prices. That is saying the cartel may have powers that can limit price persistence. It is not a reason not to infer price persistence in the counterfactual. That is illogical. But to repeat, nobody had any difficulty in saying that this data was data that could be used in the model to infer the counterfactual if it was a real effect. Mr. Parker's answer, his only answer, was that this was a statistical correlation. It didn't affect realistic economic results. Now, and that was, as I said, a change of heart after he saw what the model spat out. And, my lords, so the fundamental problem with all of the judge's judgment, 114 to 116, is he has said there's no evidence when there is the clearest possible statistical evidence, which is accepted. And he has misunderstood that. Now, coming on to the question of acceptance. Now, it is of course true that in 134 to 137, the judge is looking at this data in the context of the overhang point. But he goes in two stages. So firstly, 134, he discusses the graph you've seen. Then, Dr. Van Laan shows, that's actually a finding, that the price series used is persistent, by which he means that the present price depends at least in part on the price in previous time periods. And this implies if there was an overcharge during the cartel period, the price in the post-cartel period would also be affected. So again, two conclusions, but the first conclusion is the statistical one. Dr. Van der Laan carried out a mathematical analysis, summarised in terms you understand. Dr. Van Laan says this means in real-world terms that the price for a monitor panel is partly determined by the price in the prior month, and so on. And he concludes. So again, 2 points at each stage. There's a statistical point, and there's the conclusion. 135. Dr. Van der Laan summarises evidence in the joint memorandum as being the price of an LCD panel in a month is partly determined by the price of an LCD panel in the previous month. That's not just about the cartel period. That's the whole data set. And then there is a conclusion as to the overhang. Mr. Parker's response is, I don't consider Dr. Van der Laan has demonstrated price persistence for 9 months. And we've quoted all this. Dr. Parker then is concluding as to the effect of the data set. 136. When this issue was explored in cross-examination, Mr. Parker changed his evidence. What he had described in the joint memorandum as being consistent with price persistence for almost 2-3 months now became a statistical correlation in prices. Not, you can't use the data. It's not logically applicable to the counterfactual. No, it's just a correlation, so you can ignore it. And then, in other words, Mr. Parker's all evidence on this issue was close to the opposite of what he was apparently saying in the joint memorandum. And then he makes the correlation point again. And then I cross-examined him, as you will imagine. And in short, the judge did not believe him. I put to him, you subsequently realised the implications of price persistence for the overcharge estimates. That's the cause of the change. Mr. Parker's response was to say, I hadn't considered the implications, I'd spent more time thinking about it, is it economically plausible? The judge then asked, because the judge was all over this, I asked Mr. Parker if the effect of his oral evidence was he wanted to change what he'd said in his joint report, to which he responded, I would say replace price persistence in the last sentence with statistical correlation in. And then he goes on to the overhang point. This change of position, 137, was unsatisfactory. Mr. Parker is a highly accomplished economist and statistician with very substantial experience of giving advice and evidence in competition contexts. This change struck me at the time he gave his oral evidence and strikes me now as a substantial change of view that would require a clear explanation as to how the error came to be made and a substantial justification before I could safely accept it. Stop there. He has accepted Parker. He has found that Parker is wrong. He has not accepted the change. So on the statistical evidence, he has found, before we get on to the passage I probably erroneously focused on before about inherent probabilities, he has found that the data shows price persistence. That is the clear result of the judge's findings. He then goes on to say, I conclude the inherent probabilities are as Dr. Van Laan says. I accept there is an argument there might be some ambiguity about that. Is by inherent probabilities the judge referring just to the bits that followed about post-Cartel overhang, or is he also referring to the statistical evidence? I would submit the latter. There's quite a lot where there's clear conclusions. So, for example, 135, Dr. Van Laan summarises evidence in the joint memorandum as being that the price of LCD panel in a month is partly timed by the price of LCD panel in the previous month, in the data. And that is part of the inherent probabilities. The inherent probabilities are also, is this just a statistical correlation or is it a real effect? So you would, I submit, be in error in reading inherent probabilities as just talking about the overhang point. But even if I'm wrong on that, the previous sentence does the job. Now that having happened, we were, or should logically have been, in a pretty good position to prove that price persistence should be incorporated into the model, because the effect of that finding is that the data set, before, during and after, includes price persistence. And the judge has certainly found no coherent reason to say that you wouldn't expect the same price persistence in the counterfactual, which is the same market with the same features, of course. But and just before we leave it, just look at 141, first sentence. Mr. Parker's view was that the post-Cartel effects attributed to price persistence would have ceased to apply after a period of 3 months from the notional end of the cartel. He accepts Mr. Parker's evidence of not up to 9, not up to 7. But that's because he's accepting it up to 2 and up to 3. And frankly, given the data, he would have no choice, rationally, to do anything else. Now that then takes us back to 113. And the judge says, and you'll have read this closely, I won't repeat it all, at 113, he describes Dr. Van Laan's conclusions as being based on assumption. But when you look at the passage quoted, that is because Dr. Van Laan is making the point I've made to you. Once you've got price persistence in the actual, there's a natural inference to the counterfactual. He says in the counterfactual there'll be no reason to assume that price persistence will be different in the counterfactual period. And the judge then describes that as speculation, but it's not. It's obvious. And likewise, at 114, he's just missed in the second sentence that there is clear evidence of such a phenomenon in the LCD screen industry. And likewise at 116, while I accept that price persistence may in principle be a factor, whether it is in fact an appropriate factor depends on the market or industry being considered. If there is no such evidence and none was referred to by Dr. Van Laan, there's no utility and significant mathematical risk in including it. But of course, Dr. Van Laan had given the evidence, and then in the passages I've shown you in Van Laan 3, it said, this is the evidence I'm using for the modelling. The judge has simply misunderstood that. Now,
I mean, does Dr. Van der Laan anywhere say, I've separated out the cartel period and only looked at, for example, the data for the uncartelized pre-cartel period and there is price persistence in that.
But no one suggested that was an issue.
Sorry, Dr. Van Loan was actually asked a question about that. I'm hesitant to
I'm sorry
interrupt.
if I misunderstood that. Can you give me the reference?
Certainly.
Oh, not pre-trial, at least. It's not in the exchange of experts. But if you can give me a reference, I'm sorry about this.
So it should be supplemental bundle, tab 40, page 1561. Transcript, day 5, page 98, line 15, page 99, line 7. And I had asked Dr. Van and he had confirmed.
I think I'll take it from there. So let's look at this passage. He's cross-examined on this. And if one picks it
Give me
up,
the page number again, please.
so 1560 in tab 40, which is in volume 4. So if one picks up from 1560, you have him talking about the theory of price persistence, and then he says, point I think I've made to you before, at 197, the cartel period, a lot of the uncertainty is taken away. This is the uncertainty that can make people persist in prices, because that's the whole point of the cartel.
So 1560 at page
97 of the transcript. So he explains 96. The theory for price stickiness, price persistence, is that one of the probable explanations, it's 96 to 1560, is that people are reluctant because there's incomplete information to make very drastic price changes. If there's some indication of justified change. That's basically there's some persistence in price. Then at line 6, now in the cartel period, a lot of uncertainty is taken away. 19, this is also talking about the actual. So there may have been some reduction in uncertainty, but overall I'd assume there'd be still so much uncertainty, there'd still be price persistence also during the cartel period. But of course, that's only talking about the actual. There's no reason to infer you don't have price persistence in the counter. And then, yes, the price persistence, this is at 98, the price persistence calculations under a specific period, so they only apply to a specific period. But you're assuming there's price persistence in a period of 2-3 months. No, the calculations show there's price persistence sticking up to a longer period. But the model rate for the cartel period as well, it's not just dealing with the counterfactual, is it? That's true. There's no basis for inferring from 98, from 2-3 months, 2-3 months price persistence, so there would be the same price persistence to counterfactual. I think in the counterfactual course, the analysis was done over a bigger data set, over more periods. That's the point I've made to you about before, during, and after. I haven't checked the sensitivity analysis if I would just do the pre-cartel period. So he certainly thinks that it applies to the counterfactual and is a valid modelling assumption. So, coming back to the judge's judgment, the judge has given no reason other than criticising the natural inference of speculation not to accept price persistence in the counterfactual. The other thing the judge does is says there's no evidence of long-term contracts. But I've already shown you that he was confused there because he says it's not immediately clear how long-term supply contracts relevant to costs could cause price lags. He had in mind the input contracts of the cartelists, not their customer-facing contracts. Now, there is, in fact, good qualitative evidence in the bundles and there at trial of qualitative evidence of price persistence to explain it as a phenomenon. But just to be clear, we do not need that. You don't have to have that concrete evidence if you've got a good rational economic explanation which can be shown to fit the data. To the extent we need it, we have good qualitative evidence of price persistence. Firstly, you have long-term contracts, evidenced by Mr. Lim and the decision. And I've shown you Mr. Lim. I don't want to pick it up again. But he refers to monthly and quarterly price negotiations in the framework of a long-term contract. That naturally will create price persistence. Mr. Musa argued, well, if you don't know the specific price terms, you can't draw much. But that's not so. It's a natural inference that a long-term contract, one way or another, will stabilise prices. There is going to be inertia created by the relationship. They're likely to have terms providing for periodic renegotiations. These are not just bundles of spot contracts, of course. So just the decision saying you've got long-term contracts is a good starting point. And of course, the error Mr. Musa works in is to say you have to have concrete evidence of long-term contracts. Well, that's not so. If we've got a data set and plausible explanations, that's enough. But here it goes beyond plausible explanations because we've got evidence of long-term contracts in Mr. Lim and in the decision. Now, of course, once the price persistence point had come up, and we were saying this is what's happening, LG, who have their own contracts, of course, are able to disprove it if they wish. Saying that's just not true on the facts, but they have not done that. Now, and to understand why there may have been less evidential focus from our side on getting all sorts of details around the picture, we had an acceptance from Mr. Parker of a real effect right to the door of trial. Now, but while we're there also, this idea that you have to suddenly go around producing wadges of long-term contracts to prove price persistence when you've got a good relationship in the data, that's inconsistent with Mr. Parker's own approach previously. If we turn up the supplemental bundle, volume 1, at tab 12, which should be in the physical volume 2, and we look at page 684, Mr. Parker, in his first report, ran price persistence. This is at 627 to 628. He did so without requiring evidence of long-term contracts, but because it was a plausible explanation that might fit the data. He rejects it, 627, because it produces odd statistical results. He's running 1 month lags. He's not running 2 to 3 month lags. But he did not say at any point in these passages, this is incoherent, this is nonsense. I can't do this without a chunk of long-term contract. And indeed, that is because it was quite clear he understood and indeed accepted the plausibility and rationality of modelling for price persistence. If we go to 8.18, 699, he says it's more likely that any overcharge is passed on when the infringement lasts an extended period of time. He's talking about pass on. This reflects there may be a delay in passing on cost increases, particularly to factors such as long-term contracts. And also, in the context of the concept of umbrella effect, that's the effect of the cartel price on non-participants who basically follow along, at 7.11, page 693, you see, I expect non-participants would have only observed the market price increased, and it was likely to be profitable to increase prices themselves with some delay. All this before the change of heart, of course. So that leaves only the idea that somehow price persistence is an irrational thing. Doesn't make any sense. But there's all sorts of reasons why it's rational. You've seen them in Professor Bernheim's report. Price smoothing, not shocking the customer, uncertainty, which Dr. van der Laan referred to. You've seen the evidence of Bernheim, those reports, Bernheim and Carlson, saying this is what we would stand common practice to do. I shouldn't use the word standard, of course. that it better explains the data, and so on and so forth. This is not an irrational structure. This is just a change of heart by an expert once he saw what it meant. That takes me to, well, Justice Snowden's question, why does including price persistence in the model have this effect? But with respect, my lord, you're starting from the wrong premise. You are assuming that Mr. Parker's model is a good one. And with that assumption, you're saying, why is there such a big effect? But the way we would put it to you, my lord, is it's a bad model. And once you realise the price persistence model is a better model, it has much higher R squared, it has high adjusted R squared on both notebooks and monitors. It is statistically significant for notebooks and monitors. It simply fits the data better. So the reason why there's a discrepancy is because the data in fact shows a significant overcharge, and Mr. Parker's model is a bad one and understates it. That is the heart of the answer to your question. The second way of putting the answer to your question is this. You'll see that Mr. Parker's model fails Ramsey for monitors and notebooks. Dr. van der Laan's price lag model passes it for monitors, but not notebooks. Ramsey, we know, means there's an omitted variable. So what we know is that at least for monitors, there is a higher chance of an omitted variable from Mr. Parker's model. It is a bad model, and it therefore does not explain the data as well. And that is the reason for the difference. The price lag model is picking up the reality, which is the reality of a high overcharge. Well, that was what I had to say on ground 2A. Unless I can assist you further on that, I was going to move on to ground 2C.
Yes, you're aware we're stopping come what may at 3:30.
Oh yes, there's no problem with that.
Good.
That takes me to ground 2C. The court asked a question as to when the aid memoir was prepared. It was prepared by Dr. van der Laan, and we handed up an oral opening, which is some days before his examination in chief. He then confirmed it in examination in chief. Now, one point that fell from the court during Mr. Moose's argument was whether we might be engaging in telescopic focus on this robustness ground, that we're picking up a point that wasn't really the heart of what was for the judge and blowing it out of the proportion it had below. That was not, I should clarify, a point that Mr. Moose has made in his written documents. It's not been suggested by them that we hadn't argued this. Now, we have therefore gone away and dug out the relevant patches of our closing. When you read, not all of them are in the bundles so far. I have them here. If you wished me to, I can take you to them and show how this is the same case we ran below, in all substantial respects. And there's no question of telescopic focus. So the question is whether you want to see those extra passages from our closing submissions.
Well, if you've got them there, why don't you hand them up and just give us the references so we can look at them if we feel the need to.
What I will do then is give you a few highlights without going through it at length.
Can you make sure that anything handed up gets sent to us?
We will.
Soft copy as well?
I'm obliged. Part of this is in the previous hand-up when we gave you some of our closing. Annoyingly, I thought we were going to have it all in one go. No. So part of it is here, and part of it is in the previous hand-up. Do we have the previous hand-up to hand? Let's hand up the previous one as well, just so we have no problems.
I think I've got this. This is from tab 46.
That's the one. There's the tab 46 one. We're all good?
Certainly.
There we go. So, just to run through this very quickly, so in this document, if you go to the further hand up, first you have extracts from the opening skeleton at trial. I'm just flicking through it quickly, and we've been more selective with the opening. 261, 266 are taking the points on inherent plausibility about the notebook model spitting out a null result, 261. 266 is taking the $100 point. Then moving to the closing, page 15 of this new clip, we discuss inherent plausibilities at some length and why you mustn't blind yourself to that. And we skip past that. There's a discussion of the actually the law on downstream pass-on at paragraph 54, just so you see we did indeed stress all the case law on downstream pass-on that we now rely on, with one exception, of course. The Court of Appeal in Rommel wasn't available to the judge, but we relied on the CAT. Then, skipping past, we then get to oh yes, I'm sorry. Now we go to the clip of yesterday, the one that should be bundled. There's been a discussion of Dr. van der Laan's model. Just so you know, that took 8 pages. It was not the centre of our case. We then spend much longer on Mr. Parker's models. Then Mr. Parker's model is addressed from paragraph 37. And then you see page 38, paragraph 106. We start with lack of robustness, the very point we've been putting to you. We then discuss at 107 to 109 the absolute level of demand point, which is the model which just changes that aspect of the semiconductor billing indicator. That's 107 to 109. We then talk about other models which lead to an implication of lack of robustness, 110 to 111. We discuss the endogenous demand indicators at 39 onwards. And to be clear, 115, in the circumstances there is plainly a material risk of endogeneity, and Mr. Parker should have evaluated the use of other demand indicators seriously and at least reported them. We then go through all the models. We then discuss the price persistence model, of course, our favourite, at 122 onwards. And then we discuss we hit Ramsey and R squared at 133 to 134. We discuss the amended Parker model, that's with the explanatory variables. And then we come to the end. 148, Parker's model produces a notably bad fit with R squared below 0.5, which only improves significantly once price lags are included. Then 150, we do exactly what I did for you when I concluded ground 2C. Taking Dr. van der Laan's models together, they show that Mr. Parker's 5.4% for monitors and statistically insignificant results for notebooks are plainly wrong. They're not robust. Much better estimates taken from the consistent picture produced by Dr. van der Laan's models. These support, and then I refer to the business confidence and GDP growth models in A. Then in B, that should be 18.1, not 1.1. That's talking about the amended Parker model in green. Then an overall picture of 20 to 40% from the models in the bottom, in yellow at the bottom. D, very strongly, this is the price lag model, which is far better than Mr. Parker's model in all respects. And then we discuss some of the other models and their superiority in terms of Ramsey and R squared. And then we conclude in much the same terms as I did to you. So the idea this is telescopic vision could not be more false, my lords, my lady. We were careful to run the same case on appeal as was the heart of our case before the judge. But he missed it. Now, that takes us to the points on 2C, which I think I can deal with rather quickly. Because again, I'm going to ask you to consider I'm sorry, Millie, I see trouble on your face.
No, I'm just trying to fit these various bits together.
Again, I'm going to ask you to think back and consider how much Mr. Musa did not answer. Very important. Because in fact, he barely touched on the arguments for ground 2C. He didn't challenge the principle that if a small plausible change produces very different outputs, the model may not be robust, which was of course accepted by Mr. Parker. That was Parker 2, A.35. Tab 13, 901. Also joint memo, paragraph 34, tab 17, 1126. And Dr. Van der Laan 2, paragraph 1.2.12, 1.2.13, tab 8, 415. That was not challenged. He didn't challenge the obvious points that good regressions must fit the data and that specification of variables is inherently a sometimes imperfect matter. He didn't challenge the points I put to you about how, well, when you think about it, this semiconductor billings indicator obviously is at quite a distance from the data. So treating this as set in stone is an error. He did address the proposition that you should test implausibility by reference to inconsistency with other facts. He did say a few things about that. And he took you to a passage in Mr. Parker's evidence where Mr. Parker said you shouldn't approach a model with an a priori assumption or expectation of a particular result. You may recall being taken of that. And that's at tab 50 of the supplemental bundle. But if you look closely at that passage, he didn't actually deny my proposition. So 1656, page 123 of the cross-examination. Question, that implausible results might lead you to reconsider whether you used the correct variables, whether the data set was sound. Answer, as a general matter, that's right. I just don't think that when you're thinking about the thing you're trying to measure, that you shouldn't be assessing the goodness of your model depending on what the answer is on the infringement indicator. Now, there's a subtlety there, that he has accepted that an implausible result might lead you to reconsider whether you've used the correct variables. And that's obviously correct. To the extent necessary, of course, we rely on the reasoning of the Court of Appeal in Royal Mail, which say, well, when you have a model that spits out 0, or something we see here, statistically indistinguishable from the 0, the court reasons that that is implausible and has done so on sound reasoning in Royal Mail. As to the judge, he relied for his reasoning in paragraph 21, where he said, I'm just going to do econometrics, that's it, nothing else factors in. He relied on paragraph 145 of the Commission guide, practical guide, which is in Authorities Bundle 2, just to show him relying on that. If we just pick up his judgment and we go to paragraph 21, he's saying how...
So Authorities Bundle, give us the...
I'm sorry, I'm just in the judgment now, Core Bundle 61.
Cool.
And he says, the most you can infer is some practical effect, and that reflects the point made by the Commission in paragraph 145. But in fact, if you go to paragraph 145, which is in the Authorities Bundle at tab 26, it's actually dealing with a different point. It is saying that statistical models of how cartels have behaved in the past, paragraph 142, this is 1930 of the authorities bundle, tab 26. He's saying that those statistical models, in 145, don't replace the quantification of specific harm suffered by claimants in a particular case. That does not give a reason for discounting inherent plausibilities when assessing modelling generally, when the decision shows conduct of a scale that's just implausible, wouldn't produce a major result. And it certainly doesn't displace the idea that if a model spits out a result statistically indistinguishable from zero, that is inherently implausible, not least given raw amount. In terms of other building blocks, I took you to Ramsey, what the judge said on that. I took you to R squared and what the judge said on that. And he, of course, uses the term sense check for R squared. Now, as necessary, I put to you, he may have missed an extra trick there. R squared is, of course, a sense check, but also it is an estimation of the proportion of the data that is explained by the regression. So he may, and that's uncontested between the experts, I've shown you that, it's Mr. Parker's own evidence. So describing it as a sense check, which is something of a vague term, may slightly downplay the force of what you do with this indicator. But even just using the judge's sense check term, that is enough for us. Because what then, those are my building blocks, what then has the judge done? Now, did the judge come back and test the robustness of his model in response to small plausible variations? He didn't. He adopted the approach of saying, I'm going to pick no price lags, I'm going to pick semiconductor billings. He never stood back and said, okay, they may not be my preferred models, but do they input into my assessment overcharge? He never did that. Mr. Musa's response to this was simply to repeat the point that the judge had decided the variables. And that's it. So you can then ignore everything else. That is the category error. That is the logical error, which we said in our closing, as I've shown you, the judge should not make, but he did make, even though it was contrary to the common ground between the experts. Did the judge come back and test his model against the plausibility of the no statistical significance result for notebooks? He did not. Nor did he test it against any of the other aspects of how the decision created an inference of a very substantial effect here, because he ruled that out, paragraph 21. Did he come back and test his results against R squared and Ramsey? No, he didn't. Now, you'll recall there is a passage when he's discussing the business confidence models where he considers R squared for those models. And he says, well, R squared isn't materially different here, so I don't see I should adopt those models. What he never does is stand back after the whole exercise, consider all the models, including price lags, with their much higher R squared, and say, oh, I should think about that. And as to Ramsey, he crucially makes a mistake here, because, of course, in his paragraph, I think it's 51, he says, well, Ramsey might tell you that there's a missing variable, but that may matter or not, depending on whether there's a reason to know what the missing variable may be. But we know what the missing variable, I would say, is, but for this argument, may be. It's price lags. And he's never come back and interrogated whether, given the failure of Ramsey of his model, he ought to be, if not adopting, thinking about and inputting into an overall assessment in an inherently uncertain business, other indications of overcharge. And a limited upwards adjustment just does not cater for this. A subjective adjustment to deal with a little bit of endogeneity and a little bit of post-cartel price persistence. The position is particularly striking when he had accepted that the very model he was adopting had an inherent flaw. And the inherent flaw is his acceptance that there is a limited degree of endogeneity in the semiconductor billing indicator, which you see at 107. But we know from the Commission, and he himself quotes it at 51, that page 71 of the bundle, in presence of endogeneity bias, no reliable result can be inferred from the estimation. Given those factors, the proposition that he shouldn't have stood back and looked at the other models is untenable. He plainly misdirected himself, and he plainly failed to do the appropriate course, which is the one we counselled on him in our closing, which is to consider inferences from a range of models, which of course were much more consistent between themselves, only his model being the one that spat out that low level. Well, that concludes what I have to say on ground 2C, and I was then going to rattle through downstream pass-on, if that pleases the court. Yes. Now, firstly, a point was taken on our grounds of appeal. Mr. Musa likes pleading points. To say that we could only, the only result you can reach is a binary one, either judgment upheld or 0. And with respect, that's not the right approach. We indeed, of course, in our grounds say that there's no direct and proximate causal link, and therefore 0. But if the court's reasoning gets the court to a position where the court thinks, well, Mr. Raphael's right as to a lot of it, I don't believe there's a direct and proximate causal link to 65%, but I think there might be one to 25%, then that's simply one of those situations where the court applies judicial judgment and reaches the right result in the parameters of the appeal. And just to make clear that we have that is our position, and that this is no shock or surprise to anyone, we addressed exactly this point in our supplemental skeleton at paragraph 19 in response to the same point by Mr. Musa. We say, no, our case is no DSP is proven, but anyway, 65% is not proven to the standard. So it's for the court to assess what is the logical consequence of our arguments. Right, that leads us into the law on downstream pass-on. Now, this is actually an interesting problem. There are different ways that the law could have been resolved before this court's decision in Royal Mail Cat. One can imagine Royal Mail Trucks case. One can imagine a situation where pass-on is regarded as something to be dealt with flexibly, where you can just put anything into the mix and there's no reasons for constraint. But it's quite plain that the reasoning driving the CAT in all the cases you've seen and adopted by the Court of Appeal is no, something more is required. It's a direct and proximate causal link, and there are sound reasons for that, both in the context of mitigation outside. I mean, just consider how tight actually mitigated losses needs to be in a commercial case. Westinghouse, you've got, they lose out and they buy a replacement machine and it works better. It's not surprising in that very tight situation that you've got actually mitigated loss. Nothing like this case. And in competition, there's extra policy reasons, of course. If you open this up to effectively speculations on the basis of what rational people might do, what rational people might want, the disclosure burdens become immense. It undermines the principle of effectiveness. But I'm not seeking to create law. These points have been decided. You require a direct and proximate causal link. That is a high test. You've seen the judgments of the CAT saying, well, we just, in those situations, you can't be sure exactly how the pass-on happens or that it would happen. Just speculating from economic theory that rational people might do this is not going to be enough. You've seen in Autoliv, in particular, what they required in Autoliv is where you had a very small overcharge, Cat said, well, unless you've proven that this business micromanages its costs in that sort of way, you have no chance. The idea that, oh yeah, but generally people do pass on because they face tight margins, was simply nowhere near enough to cut it. So the law is settled, and it is inconsistent with Mr. Moose's position. Now, all those cases were cited to him. That's going to be in the closing I've given to you. It was always our case. This is why we didn't go for a percentage. There just simply was no proof sufficient to satisfy the test of a direct and proximate causal link. And this is why, when looking at the law, there are layers to it. It is true that if one wasn't applying a test of a direct and proximate causal link, the idea that you would just have some kind of soup into which economic theory might help you out might be attractive. But that's not how it works. Because the point is, once you require a direct and proximate causal link, once you require that the pass-on must arise out of the transaction, that's the sale to the claimant, it's going to require something a lot more than speculations based on economic theory, because rational people tend to do this sort of thing in these sorts of circumstances. I don't need much of the detail on my contrary factors. They are icing on the cake for me. But once you add them in, it becomes still clearer. What do we know about the facts here? We know that extensively and in a majority of cases, my clients were using psychological pricing thresholds. No proof that they didn't use it in 49%. That's not what the judge means. We know that they extensively used warranties. And the judge says, well, you may be disincentivized. Now let's just take his finding at face value. Assume I can't push back on that particular bit. Well, nevertheless, he's accepted that as a general matter, we may be disincentivized. If you've got that in play, where is the direct and proximate causal link between these overcharges and any particular concept of pass on? You're just saying, well, I think it might be so, so I want it to be so. Add in also other key facts. There are findings the judge and I've taken you to, particularly 2 for 1, about what the policy was of the claimants, namely to win market share. There are findings that in many cases they will aim to be psychologically pricing, and they may deal with problems of cost by package substitution. Where then do you find a direct and proximate causal link proven to any particular aspect of pass on? It might have happened in some cases, it might not. You might form a guess, but you do not have a direct and proximate causal link. The point is not that there's some threshold where once you've satisfied a pleading threshold, you're in the game and then you can just look at economic theory how you like. The point is that once you are considering how economic theory works in the context of a test of direct and proximate causal link, that is why it's not going to get you home. That is why you need something more concrete. And that is in particular because economic theory is all about assumptions. A rational person might do this. A rational, efficient person might do this. A rational, efficient person who knew what they were doing and reached the right decisions can be inferred to do this. But the real world is full of fools. The real world is full of people not doing what the economist models say they should. So where do you get the assumption that people have behaved the way the economist models say they should? Well, you can't assume that, not least here. There is a striking passage, paragraph 212 of the judge's judgment, which says, well, if you don't pass on, you might go out of business. Well, what happened here? The claimant did go out of business. And this is why the economic theory does not get you close. Then turning to the specific facts here, it becomes even stronger. We have, on top of psychological pricing, on top of warranties, we have the variation in margins. Now, there's one important passage in the judge's judgment which might be cryptic unless you unpack it. And if we go to paragraph, core bundle tab 5, and we go to paragraph 223 of the judgment, I agree with Mr. Augustine. He's talked about the BOMs, that this material does not show price fixing on a cost plus basis in the usually understood sense of the term. He makes good that point in a bar graph presentation, paragraph 1322 and 1324 of his third supplemental report. So that's evidence he's accepting. But I don't think you've seen that. And so let's dig it up. It's in supplemental bundle 1. Augustine 5, which is in tab 5, and the relevant page 242 of the supplemental bundle. And these are the graphs. This is what the judge is talking about. And you see there's the bar graph and then there's the scatter graph. This is the scatter of margins that the BOMs show. They're all over the place. Now, what does that mean? It means that in particular cases, and of course, what is a margin? A margin is the difference between your cost and your sales price. Now, if you are pricing on a cost plus basis with a fixed margin, well, then one can see you might be in the game for pass on a direct and proximate cosmic basis. But once you know there's a scatter of margins, then it all disappears because you simply don't know whether in that particular case or generally it's not all just been absorbed in the scatter of margin. So the judge's judgment throughout simply, it takes three little bits of fact, none of which are remotely capable of supporting a direct and proximate causal link. Note, which didn't defend the DRAM email. The BOMs don't show a direct and proximate causal link. They contradict it because the margin scatter. The price generators, firstly, the judge felt they didn't really establish anything and they were in a tiny shred of the market. Anyway, so those three bits don't get you anywhere. What's left? Just economic theory. Now, Mr. Musa relied on the market. I said, oh, well, you've got quite a competitive market here. But again, that's just assumptions. Because what we do know is that the claimant's margins were 12 to 19%. That's the figures from Mr. Parker. Or 15.5%. That's the figures in the corrected letter we sent you. It's much the same thing from Mr. Augustine. That's quite a fat margin. The idea that you can assume that in that kind of market, operating that kind of market, you're going to pass on small sums, that can't be assumed. Again, it's just guesswork. And the kind of guesswork that the cat is trying to set a bright line rule down to stop happening, to avoid the massive costs of trying these things. The two further points before I conclude. The other thing that's decisive against the judge is that he cannot distinguish between cost reduction pass-on and price pass-on. And Mr. Musa took you to 231 and said, oh, no, I'm not talking about cost reduction price on there. The judge isn't talking about cost reduction. He says the judge can be talking about package substitution. And this also comes out at the bottom of 233. This is significant because passing on does not involve merely increasing the price of the product, but can easily be achieved in a market by choosing different mixes of component parts, and in doing so sticking to a psychologically chosen price. So he accepts that could be what's happening. Mr. Musa says, oh no, don't worry, that's price pass on. No, it isn't, or at least you can't show it is. Your swapping in different components. You're swapping in the different memory chip. You're not selling alongside the charger. You've saved some money. You're selling something different. Now, I suppose you might notionally do some complicated valuation and guess that some bit of it may have gone up in price. But the idea that you can trace through a direct and proximate causal link through that kind of set of facts to an increase in the price of the package, rather than just saving money on the chip or whatever, it can't be done. So this evidence is fatal to the judge's reasoning. The other thing that's fatal to the judge's reasoning is the low level of pass-on. Whatever he does say about margins being tight, whatever he does say about this being quite a competitive market, he simply failed to say, actually, when I think of that overcharge I've found, it's really very small. How is that going to be noticed, especially when you think that's the total overcharge? He's failed to consider utterly how that might impact psychological pricing, because of course psychological pricing is going to be much stronger incentive when the tiny overcharge is there, rather than the big one. Mr. Booth says he did consider it, but when you read 270, all he says is, this is a principle. He then doesn't go to cross-apply it. So that
is the judge entitled, in paragraph 243, to say that the idea of zero pass-on is entirely unreal?
Again, I come back to my testimony. It is not for us to prove an amount of pass-on. You can speculate that there may have been some passing on there, but that is not the test. This is why all along our entire case has been about the test. You might think, yes, but I think I'd guess maybe there might be some pass-on. I don't know how it happened. I don't know where it happened, but yeah, it makes some sense to me it might have happened. That is not a direct and proximate causal link. And the final point is, should you cut them, effectively change things round because of the lack of evidence? Now, it's true, there was less evidence than a fully informed court would have really wanted to see, essentially because of the insolvency. 20 years ago, judge finds we've done everything we can to get witnesses, but no one's willing to stand up for an insolvent company all those years later. This is 291. He finds that we've done what we can. So he's not drawing any adverse inferences against us. As to disclosure, there was no basis to draw an adverse inference. There was less documentation than might have existed, but there was no basis to draw an adverse inference. But it's an error to assume, however, that means there wasn't much evidence. 20,000 documents were disclosed. Only a very few were put into the trial bundles. Why? Because they didn't prove pass-on. So the idea that this is some kind of documentary void is an error. You've got a documentary selection by my learned friends of their best hits, and they don't work. But even standing back with all that, outside a situation of adverse inferences caused by bad conduct, which was not argued on disclosure, failed on witnesses, not pursued on this appeal, you have no basis to turn round the burden of proof. The burden of proof is for good reason on them, and it is set at a high standard by the Court of Appeal and Cat in Royal Mail of a direct and proximate causal link, and they have failed to satisfy it. I might just consult very briefly those behind me. I think that concludes my submission. Lord and Lady, I'm grateful for your indulgence, and that concludes my submissions.
Right, well, we will reserve our judgment. We will send it to you in draft in the usual way. It will come with the embargo, which you know about, and you also know that the court takes that very seriously. We will hope and expect that in the light of whatever we decide, you will be able to agree an order between you. Not prejudging anything, but if whatever we decide does require some adjustments to the figures, and you need a little more time to agree that, then that's fine, but please try and agree without waiting for that. The usual things like costs and if there's any submissions on permission to appeal, we'll have those as well. Have those anything you can't agree, we will have in short written submissions and resolve things without hearing. We will want to hand down our judgment within a short time after sending it to you in draft. So it may be that we will do that anyway and leave you to resolve any financial consequences of the judgment once the judgment is out there in the public domain and you can discuss it with whoever you need to discuss it with. Hopefully that's clear. It remains only for me to thank everybody, those who have spoken and of course those who have supported them. We realise that particularly in a case like this, it's a team effort. Thank you very much.
Quarter round of table.